Well, good morning, everyone. Thank you for being on time. My name is Margie Graff. I'm the President and CEO of the Greater Rockville Chamber of Commerce. Welcome to our webinar this morning with flood law. Today, we're talking about the backlash error, navigating DEI and compliance in a changing legal landscape. I would like to introduce you to our moderator, John Flood. John is the founder of Flood Law, LLC, which is a law firm based in Rockville, which serves clients in Maryland, Virginia, Washington, D.C., Pennsylvania, and New York. John is an Air Force veteran and former Air Force JAG officer. He is also a trial lawyer who helps clients on issues in the areas of labor and employment law, defamation, and business disputes. John is also serving as the vice chair of the board for the Greater Rockville Chamber of Commerce. John, over to you.
Margie, thank you. Good morning, and thank you to the Greater Rockville Chamber of Commerce for helping to host this webinar for us this morning. We're very excited to be able to talk with you all about an issue that we know and are seeing every day that is very important for employers, and that's the issues Margie mentioned of DEI, diversity, equity, and inclusion, and the backlash that's really been brewing against employers in relation to any continued use of such programs and other efforts, maybe less formal, to promote DEI in the workplace. I want to introduce, and really glad to introduce, our two speakers for today's discussion. First, Joyce Smithy is a leading employment lawyer in Maryland. Joyce's firm, Smithy Law Group LLC, is a robust team of lawyers who work primarily on behalf of employees, but also at times for employers in relation to employment law issues, including claims of discrimination, harassment, pay issues, and retaliation. Joyce has practiced law in Maryland for more than 22 years, and I think overall more than 25. She's a leader in the work of the Maryland State Bar Association and also actively involved in many community and civic endeavors. Joyce worked with us and spoke at a webinar we hosted last February. She did an excellent job. She has wonderful insights based on her years of experience, and we think her comments today would be really helpful for you all to consider on this issue. I'm also very pleased to introduce my colleague, Anthony Markavich, who's Flood Law's principal lead counsel for employment law. Although Anthony looks young, as you'll see in a minute, he's practiced law, I believe, for right at 20 years now. Anthony started out with me at a large international labor and employment law firm in D.C. He's worked with our firm previously in leading our labor and employment law work for employers. Most recently, Anthony worked as the VP of HR and employment law for a fast-growing e-commerce company in Pennsylvania. I can say without any doubt, Anthony is incredibly creative lawyer, and he really loves to help employers solve problems, to include on the front end versus in litigation when things are always more time consuming and expensive for clients. So with that said, I want to hand it off, and glad to hand it off to Anthony and Joyce. Please take it away.
Okay, good morning, everyone. Let me make sure my slides are moving here. We've already done the bios, so I will just jump to the agenda. And, I'll start by just saying, whenever you sit around and talk about DEI, equity, Trump administration policy, right? I mean, these are very emotional issues, very, very political issues. So you may not agree with every perspective that's shared today, right? I'm going to start by giving my perspective from sitting in HR seats much of the last 20 years. I was a director of labor and employee relations for Bon Score Health System for 10 years, and then the HR leader at Clark Associates, as John mentioned. So I'm bringing kind of the HR perspective and the legal perspective. So this has been my take on how the issue of DEI has unfolded, really over the last 10 to 15 years, and how it's brought us to where we are today and what we can expect in the future. But if you have different perspectives on it, please put your comments in the chat. We'd love to have a discussion here, both during and at the end, whenever it's appropriate. So I'm going to talk a little bit about the move from equality to equity, what that means, employer challenges with achieving equity, and how that planted the seeds of the backlash we're facing today. Then I think we're all familiar with the politicization of equity, how that became a really important political issue over the last, 5 years, say. Talk about the precursor to the backlash, 2025, where everything broke loose. Talk about where we are now, and then hopefully help you do some planning for the future. So, for those of you who have been doing this work for a while, you may remember when DEI, diversity, equity, and inclusion, was just DI, right? Diversity and inclusion. And that was back in the, I kind of marked it as 2005 to 2015 period, where equality of opportunity was really the focus of corporate diversity and inclusion programs, right? So workplaces creating workplaces free from overt discrimination, making sure everyone had the same opportunities to thrive and succeed. This ended up being mostly in the negative sense. So what I mean by that is, prohibiting discrimination, making sure that there were not, obstacles to advancement. So we had policies like anti-harassment, anti-discrimination. It was focused more on the reactive side. The inclusion, of course, was focused on making sure people from different groups felt welcome. And we saw the advent of affinity groups, social events marking and celebrating, different groups, celebrating holidays and historical days, months recognition, that sort of stuff. But then, and those were actually, maybe ironically, right, during the equality thrived during the Obama administration. Towards the end of that administration, we started to see this move from equality to equity, right? A shift in importance from the anti-policies to more affirmative goals, proportional outcomes. Now, what do I mean by that? And it's very important to understand where we are today. Outcomes in employment, in promotions, in board membership, in salaries, etc., that reflect the makeup of the community and the country, right? That became the goal. So if we have, 15%, 13% of the population being African American, why doesn't our leadership reflect 13%? That sort of thing. That's the kind of the 20,000-foot view. The shift moved to removing systemic barriers to proportional outcomes. We heard a lot about systemic racism. That was a new term, coming into popular usage around this time. And the shift went from, again, focusing on policies that prohibited things to now implementing practices that broke down systemic barriers and drove proportional outcomes. Now, right from the beginning, there was criticism, right? Because a lot of people flashed the warning sign and said, the ends, the equal outcomes, which we all want, don't necessarily justify the means, which is discrimination to get there. And we're going to talk about that in just a second. You probably have seen this. This is from Hopkins. This, I remember actually, and I don't know who's on the webinar here. Some of you might actually remember this colleague of ours, but probably around 2014, I received an email from an HR colleague, and this was in her signature block on the email. And I remember seeing it, and it kind of hit me, and I'm like, oh, that's different. What is that all about? What's the difference here? And the idea here is that equality of opportunity, gets everyone to the starting line, but are they coming there on equal footing, right? And this is a kind of an ADA example here, right, where you need the ramp for the person with a disability to get up and be able to see the game. This is kind of presenting it in its most benign form, and we'll talk a little bit about why it became more controversial in other contexts. So the problem, I think, and a lot of you, I see HR leaders on the call, business owners, but potentially, a lot of you probably dealt with this. The problem with equity, the problem with achieving proportional goals is it's really hard, right? almost immediately, when companies jumped into this area, when they shifted from D&I to DEI, they realized that achieving those equity goals was incredibly difficult. And here are some of the challenges. And if there's anybody on the call that has been in recruitment, I mean, certainly you know this, right? The challenge is fierce competition for small candidate pools, right? Lack of candidate pipelines, because a lot of these disenfranchised groups have not had, the generations of college education and that sort of stuff. So we're just talking about a small group of candidates. Geographic concentration, right? A lot of the groups focus around major urban areas. Recruiting and sourcing expenses. It's expensive to get out and find these candidates. Employee relations challenges. As we know, this stuff is not always well received. Inertia, companies have been doing things the same way for a long time. It's always hard to change. Of course, the issue of ongoing discrimination or bias. And then what we're going to focus on today, the legal obstacles, right? A lot of companies found that when they wanted to do these sorts of things, there were legal obstacles in place. So when we talk about the origins of the backlash we're dealing with now, I think companies around this time were faced with three options, right? They could accept that progress was going to be very, very slow if they went about the traditional way, trying to source candidates, trying to win them, to hire them in a very competitive environment, putting in the resources into their recruitment teams, et cetera. It was going to be very slow. It was going to disappoint, in some cases, shareholders and stakeholders and many employees. And it would potentially impact their brands because a lot of people went out and said, hey, we're going to do this, we're going to achieve this. And then they found the going was extremely slow. They could spend scarce resources on recruitment efforts, sourcing salary and retention, just put a ton of money into the problem. But, if you're not Target or Home Depot or a company like that, you may not have that margin to be able to do that. And then what I think a lot of companies chose to do, which was the easiest solution, was to take shortcuts around one of the most significant obstacles, and that is the law, right? And that's what we're going to focus our conversation on. So at this point, right, the HR people, employers, they're sitting there trying to make sense of what the law requires. And frankly, they're getting a lot of mixed messages, right? Title VII of the Civil Rights Act, which we're all familiar with if we're in the HR world, has always prohibited any type of discrimination based on race, ethnicity, and so on, right? That it's always been illegal to discriminate against any group based on those traits. But there's been a lot of counter pressure that naturally, muddied the waters on this. So affirmative action since 1965 has been present, and that has required federal contractors to take affirmative action to advance representational goals. Very similar to the goals, over the last 10 years of the equity movement, right? That's been there for a long time. The Me Too movement, the BLM movement from 2015 to 2025, many policymakers made pursuing equity a priority, right? These were very popular movements, especially with the Democratic Party, and there was little discussion of legal obstacles. Executive orders, the Biden administration, the Trump administration, I think, got a lot of attention for its day one executive orders. But interestingly, the Biden administration did something very similar on the other side of the coin. On its, one of its day one EOs was the advancing racial equity and support for underserved communities through the federal government. And the administration's rhetoric was very pro-equity. And then, college admissions, the Supreme Court precedent had always allowed colleges to consider race as a plus factor in admissions. And many employers naturally assumed they could do the same in hiring and promotions. So even though Title VII is banning discrimination based on protected classes, right? There's all of these other voices that are actually saying, no, you could consider this. You could play around with this. So employers in this area, now that this movement is kind of coming to the fore, the law is quite unclear on it. And the result, right, is that many companies implemented procedures and practices that, if you read the law very strictly, were in violation of it. That did potentially discriminate on the basis of protected categories. So some of the things that companies did, and I mean, I saw this firsthand, and I'm sure others on the call have as well. And some of these practices may actually still be in place, which is why we're talking about this today. Requiring hiring or promotion panels to include a certain number of diverse candidates, right? A lot of companies said that. Don't send me a panel for a director or above level position that doesn't include, 20% female, 20%, ethnic minority, whatever it is, right? So that was something that was very common throughout corporate America. Favor diverse candidates in internship programs, including specifically eliminating some programs to such candidates. I mean, I've had clients who were very open. I mean, and I'm not exaggerating. I can remember these conversations. We are only hiring diverse candidates into our internship programs. Like, that was their ability to create a pipeline. That was a decision that they made, that they were frankly going to discriminate in that context to create the pipelines they needed down the line. Setting internal diversity metrics, sometimes unofficially, that resemble quotas that are illegal under Title VII and the affirmative action EO. Tied manager bonuses and promotions in part to diversity metrics. Some of you might have seen that. That was very common in recent years. Implemented essentialist trainings around implicit bias, white privilege, etc. Right? And we're going to talk about some cases that have actually found that some of these trainings potentially create, a hostile work environment. So large companies poured resources and publicity into their D&I programs, and what the result was, we had a culture that seemed to be very much on the side of these programs, and dissent was looked on negatively. So where we are at this point is, tensions are starting to rise in the DEI movement, right? We have, with the wind in the sails, so to speak, of DEI, we have people that have kind of take it over the line, that go further with it than just, its initial intentions. We have cancel culture being born, right? Where now, if you're speaking up against this stuff, some people are afraid to do it, they're silent, or they are silenced. And over time, we have a significant opposition to DEI brewing under the surface, right? Right as it's kind of cresting, and it has the administration in support of it, corporate America, right? It seems to be a juggernaut, and that's the country and HR, and they would be going in that direction indefinitely. We have this backlash brewing just under the surface, and we see that really starting in 2020, where politicians, especially on the right, recognize equity as a salient political issue, right? And it becomes a standard plank in conservative politics post-2020 to oppose D&I. We see it first in the states, which is not unusual. They're usually ahead of the federal government, right? Florida, Texas, other states, banning mandatory DEI training in universities, removing DEI offices, defunding them, etc. They're framing these issues as eliminating discrimination and ideological training, where the proponents are now accusing them of backlash or overreach, and saying they're actually, whitewashing history and suppressing discussion about administration. So this is now, even as it's kind of marching forward at the corporate level, at the national level, these disputes are happening, under the surface. And I'm going to turn it over to Joyce now to talk about this really key decision in 2023, which starts to give some legal muscle to the anti-DEI movement. Joyce, are you with us? I don't see her. Joyce, are you there? I'm going to run with it if she's not. Okay. So anyway, in 2023, right, So the Supreme Court issued a decision that actually did not relate to employers at all, right? It was about university college admissions, and it's called Students for Fair Admissions v. Harvard. And the outcome of this decision was essentially affirmative action in the college setting was struck down as unconstitutional, right? The Supreme Court held that, and it was focused on Harvard, that Harvard's program lacked measurable objectives because its stated goals, such as training future leaders, were too vague, too ambiguous, and not supported by data, right? And this is almost a situation where the colleges and universities, you can see that they were so confident in what they were doing that for a decade they had not done their homework, right? They're in the middle of this huge lawsuit, and the information that they're bringing to the table in the sense of the legal record is just incredibly thin, right? They don't have the data to back up their goals. They expected the government and the courts to defer to them. Oh, training future leaders, that sounds important. You could do what you want to get there, right? Supreme Court said, not the case, and they struck down affirmative action, based on in college admissions. So the upshot of this, now this did not apply to corporate America. It did not apply to other areas in the federal government. But when you're talking about constitutional law, when the Supreme Court is saying these sorts of practices are unconstitutional in this context, right? All the plaintiffs' attorneys out there and those on the other side of the DEI movement are saying, hey, that applies in our context as well, right? So you start to see now, legal challenges more broadly outside of just the college admissions context. So even so, we're left back to that inconsistency. We have the Supreme Court saying this, but we still have, for instance, Executive Order 11246 that's saying not only is our affirmative action programs legal, but they're mandatory, right? For any federal contractor, you need to be out there implementing affirmative action programs for minority and female candidates, promotions, hiring, etc., right? So federal law at this point is truly inconsistent. We have a Supreme Court decision saying one thing, and we still have our legacy executive order saying really very much the opposite thing. So this is now creating a lot of pressure on the equity movement, on the DEI movement, right? We have, going into the 2024 election, we have the political right successfully mobilizing its base against it, which we see on the state level. We have the left having overreached in some areas, such as, cancel culture, things that are broadly unpopular. So there's also a popular backlash against it. And now we have the Supreme Court saying affirmative action by state actors, which would apply to federal contractors and those receiving federal funds, right, is unconstitutional. So, the powder keg is there and it's just waiting to go off. And of course, the 2024 election was the spark that blew it all up. So the Trump administration took very swift action against DEI. We're not going to go into this in detail because you probably already sat through webinars, including one, by flood law last year on the specifics of that. But just very quickly, right? Executive Order 14173 ended affirmative action. Executive Order 14151, again, directly, just where Biden's was the advancing racial equity, right? Trump's is ending radical and wasteful government DEI programs, right? I mean, just the rhetoric on both sides, you could see one is in direct response to the other. And then we have the government saying, identifying high profile targets, saying in these EOs, we're coming for you. We're going to be looking very carefully at publicly traded corporations, large nonprofits, etc. So this is the environment that we're living in really early in 2024 because these were implemented, these are day one executive orders by the administration. So, yes, Margie.
Joyce is on.
Okay. Hi, Joyce.
Sorry, having some
That's
technical
okay.
difficulties.
Do you mind, Joyce, do you mind picking it up here and taking the next few slides?
Certainly can do that. And I'm ready to go on, really planning to start in on the Ames slide that we talked about on slide 21, if that's all right with you.
Okay, let me do that then. Yeah, we can. We can. So what we're seeing now, right, are the different organs of the government that address these sorts of issues. The DOJ, the EEOC, right, the Department of Labor, the wheels are starting to turn, and their enforcement mechanisms are starting to come into focus. How they are going to implement the administration's policy on this stuff, right? And we see some really interesting and unusual takes on it. The DOJ memo, this is back from May of last year, the Civil Rights Fraud Initiative. Basically, I don't know, some of you might have dealt with, false claims actions, but this is where individuals can bring fraud actions against their employers and companies that receive federal funding for, misappropriation of those federal funds, fraud, that sort of stuff. So the Department of Justice is encouraging people to bring those sorts of complaints related to DEI related discrimination, right? Now, again, I mean, a lot of this is rhetorical. These are very hard lawsuits. I really don't know how many have been filed, but it is something, it's remarkable. And if you think about how, generally speaking, the plaintiffs' bar has been aligned with the Democratic Party, right, with the left. And now we have the conservative right saying, bring these lawsuits, right? Get litigious on these issues. And it's just such a sea change. And, again, it's something that I think we're just starting to deal with as employers. EEOC enforcement, I mean, some of these titles, you have to laugh if they weren't so serious, like what to do if you experience discrimination related to DEI at work, right? This is a guidance memo put out by the EEOC. Not pulling any punches, right? Targeting DEI programs absolutely directly. So encouraging employees to file charges relating to DEI. DEI-related discrimination can include an employer taking an employment action motivated by race, sex, or another protected characteristic. And then this next one I think is probably the most interesting. Depending on the facts, DEI training may give rise to a colorable, hostile, and work environment claim, right? So depending on the content of your DEI training, the EEOC is flagging it and saying that could give rise to a claim. Now, again, are we seeing hundreds or thousands of such suits out there? No, we're not, right? But these things do take time to develop. And then we have an EEOC letter to 20 law firms. Again, this is a little bit more targeted. EEOC sent a letter to 20 law firms requesting information about DEI-related employment practices. The EEOC is prepared to root out discrimination anywhere it may rear its head. And I will note that Flood Law and the Smithy Law Group did not make the list, right? We aren't that high profile. So, but the EEOC, and this is perhaps more in line with the administration's enemies, right? Big law, but sending these letters and saying, the EEOC is watching you. Okay, I'm going to turn it over to Joyce now to talk about some more concrete legal developments in the case law at this time. And Joyce, let me know when you want me to advance, and I'll move the slide for you.
Will do. Thanks so much. So we're talking about this Ames v. Ohio Department of Youth Services. And this is the case that essentially says discrimination law protects everybody the same way. And it clarified a really important point for employers, essentially that discrimination laws apply equally to everyone, no matter their race, their gender, or their background. In the past, we were used to seeing courts making it harder, some of the courts, for majority group employees to bring discrimination claims, what we think of as reverse discrimination claims. Discrimination for being male, discrimination for being Caucasian. Some courts were having a higher threshold for those kinds of cases. And in this case, the Supreme Court rejected the idea that there should be a higher threshold for any of the protected classes and said everybody gets the same legal protections. And this means that employers cannot assume that programs disadvantaging certain groups are going to be legally safer, and any decision influenced by race or sex can now more easily lead to a discrimination claim. On the next slide. So another case to take a look at, this is Second Circuit case coming out of New York, the Chislett case. And this is a good example of how a DEI training program can create legal risk if you're not smart about how you put it together. And this case focused on what happened during DEI training sessions. And the employees alleged that they were subjected to offensive or demeaning statements based on race. And the court said that the repeated statements and practices could support a hostile work environment claim. So, for example, when you looked into that case, as you see on slide, there was language such as looking at white culture as supremacist. Reading this case in some ways, not too surprising to see that claim. I wouldn't have been surprised to see this even get filed prior to these changes, with the DEI backlash. That's very focused on, race. It's the type of case you'd see, you'd see reverse discrimination in. I predominantly do employee side law. And I will tell you of my 3 verdicts in the last year, one was a reverse race discrimination case, white male employee. Another was reverse race, white female employee. So, these have been coming through long before some of these changes, but this one really solidified that if you are handling your DEI training incorrectly, it can really expose you. So even if it's meant to educate or promote inclusion, it can cross the line, especially if you're going to use stereotypes or single out or embarrass employees of any race or gender. You need to worry about that exposure. So to the extent you do any training, it needs to focus on being respectful, inclusive of all races, and it shouldn't involve anything that would echo language like blame or labeling. On the next slide, this is really talking about, is enforcement on these DEI issues really a risk for your business, right? And of course, the government agencies and federal contractors, they're the ones who are going to face the greatest enforcement risk. And most of these organizations have already scaled back aggressive DEI programs. But for most of the private employers, enforcement has been much more selective. The government has really focused on some high-profile organizations, particularly ones that perhaps aren't as friendly to the current administration, and they've really left small businesses alone for the most part. And limited resources make it really unlikely that that's going to change and have broad enforcement against all kinds of private companies. I don't think that that's where your largest risk comes from, but still be aware that, highly visible or very rigid DEI programs, they could attract some unwanted attention from an enforcement perspective. Next slide. And this is really true. Again, I mentioned I do employee representation. Your biggest risk still comes from employee lawsuits. I run a law firm. We have 26 people at our law firm, and we have, I believe, 6 employees just answering the calls of people who want to sue their employer. That's where the risk is coming from. Employees are your biggest source of risk. Employee attitudes toward DEI have changed significantly. And if you have employees who are feeling excluded or feel they're being treated unfairly, they're much more likely to speak up or sue. And in fact, we immediately saw a change in the types of calls we were getting. We got a lot of calls from people with reverse case. It reminded me a little bit of the Me Too era, where we got so many calls from people from stuff that happened 20, 30 years ago that we couldn't really do anything about. Same thing here. We got calls from people 20 years ago. I lost a promotion and I think it was because I'm white. We got a lot of those calls. So they are going to be more likely to speak up and sue. Claims involving reverse discrimination and retaliation, they are increasing. When you look at the EEOC's annual report, you can see that. And even if you win these cases, they are expensive. They disrupt your daily business, being pulled out to get prepared for depositions, putting together documents for the lawyers. These cases, can really run up a huge cost to companies. And know that, employment lawyers out there, they're paying close attention to what we're talking about here, to what the agencies are doing, and we're seeing employee lawyers adapt to that. So, for most of us, and I do employee representation, but I also own a business. The lawsuits really pose the bigger risk for us than do government investigations. Next slide. So let's talk about the long view of these risks. I think it's a long-term shift. I don't think it's short-term. You'll see on this slide, it talks about how disability laws were expanded in 2008. The ADA had gotten to a place where either somebody was so disabled they couldn't be accommodated, or they weren't disabled enough to be covered under the statute. You had the Amendments Act change that all, but employers didn't really think it was going to make a big change at the beginning. They didn't understand the impact, but over time, if you look at what's happening at the EEOC and lawsuits, employee claims under the ADA have become very common, and you just need to expect them if you're a certain size of business. And I think it is true that reverse discrimination is going to follow that trend. It's been around for a very long time. We can all remember Ruth Bader Ginsburg saying, bring reverse discrimination cases because you're going to get good language you could use in other cases. So it's been around, but I think what we're going to see is sort of a common acceptance of them that we haven't seen before. And we're going to see as many of them as we see of other types of protected classes. So when you look at the demographics of who makes up your workforce, I think you can expect that you're going to get as many claims under, Title VII, under EEO law, from majority groups that you haven't previously heard from. And I think you need to plan for this as part of your normal risk management. I'll turn it back to you, Anthony.
Yeah, thank you. Yeah, really great choice. So what employer practices are at risk, right? I'm going to just run through them. These are things that, the literature and I personally see as risky. Diverse candidate slate requirements. I talked about that before. It's to say that you need a certain percentage of any particular group in a slate, or in anything where you're potentially making a decision in the workplace is risky. Diversity performance metrics for managers, same concept there. Tying compensation or advancement to diversity, hiring, promotion is, I think, you might get away with that for a while, but somebody doesn't get that job, and you think of it's very analogous to the university admissions, right? With that has been struck down. Internships or any development opportunities that explicitly or under the surface implicitly favor certain genders, races, or other protected classes, definitely very high risk. Employee resource or affinity groups that are only open to certain protected classes. Official or unofficial DEI targets or goals, in other words, quotas, right? A lot of everybody seems to know that quotas on paper are illegal, but a lot of companies kind of operate with loose quotas. If it's If it's talked about in an email, it's company policy, right? It doesn't have to be in the handbook. So you could definitely get yourself in hot water there. And then we talked about the risk of employee trainings. This is lower down on the totem pole, but really anything that includes essentialist concepts, you'll see that term out there in the literature as well. I think Joyce put it well, where if you're stereotyping a group, no matter what group it is, steer clear of that. That's potentially going to get you in trouble. Alternative DEI practices. Now, I think what you're going to notice is these are harder, these are slower, these are probably less effective, right? That's why people kind of ran afoul of the law to begin with, because it's a straighter line just to hire and recruit diverse candidates, but just put them in the seats. So this is more of a indirect way of diversifying your workforce, but it is more legally sound, even if it's slower and I think requires more effort. Removing college preferences from job postings and screenings, right? I mean, if you really, it's interesting. I was challenged to do this in my last job as the VP of HR, to really think through, how many of our jobs really require degrees, right? How often is a degree really an indicator of success versus relevant experience, even if it's in another field? And I think when you reflect on that, you find you can really take out some of these obstacles and some of these kind of false requirements for jobs and promotions, and really open up your candidate pools. An alternative related thing is to try alternative pathways such as apprenticeships, job rotations, to give candidates with different backgrounds, an opportunity to participate. Maybe not be committing long term, but you get to see how someone that might have an alternative background does in a particular role. And in my experience, you're going to be surprised, right? Pleasantly surprised. I think a lot of the requirements we put, especially around things like degrees or particular numbers of years experience, that sort of stuff, are exclusionary, right? When they don't need to be. Target candidate pools based on socioeconomic status and similar factors. This is what the universities have done, right? They've started to do more recruiting based on socioeconomic status, things like even single parent households, just kind of alternative, creative ways of making sure you're getting a diverse candidate pool. Again, it's not as clean, it's not as direct, it takes more effort, but really it avoids what is truly, pernicious discrimination. And I think it will achieve your goals in a way that, is more legally sustainable and will be better received by employees. And it's just, kind of the right thing to do. Targeting implicit bias through blind initial candidate screening, that's been around a long time. There's literature on that if you're interested in it. How, taking away names, taking away addresses, taking away where people went to school, where they went to high school, results in more diverse candidates getting through that initial screening stage. Now, of course, something else to think about is how you're using AI. That's not the focus of our talk today, but there is definitely a discrimination risk in the use of AI, right? Especially if you're not using AI that has been vetted and that's been created by, recruiting or sourcing company. If you're just using it willy-nilly, I mean, really significant risk there. Maybe we'll talk about that in a future webinar. And then rebranding trainings, as Joyce said, to focus on compliance and employee experience rather than any finger pointing or blame. But I will say, don't overcorrect, right? The message is absolutely not toss all your DEI initiatives, stop talking or thinking about race at all. If you do that, two things are going to happen. Number one, you're going to create class action risk on the other side, right? You should be doing analysis of your pay, of your hiring, of your promotion practices to make sure that your everyday processes are not biased, right? You want to make sure they are legally compliant. The traditional rules of discrimination continue to apply. So you don't want to overcorrect. And then also pushback will have a negative impact on retention and corporate culture, right? I'm sorry, a full pullback. You don't want to just toss this stuff. It's meaningful to a lot of people I think if you think about the workforce over as John, had to remind everybody, 20-year career. If you think about, the workplace over that time, it has changed for the better. I think it's much different. It's more culturally attuned, and we don't want to lose that. You don't want to go, back in time. It's about evolving, not going backward. So your next step, a pitch for our services. Conducting a full DEI risk audit is a good idea, and you don't need legal counsel to do this, but you may want to do it underprivileged, right? Inventory your DEI programs, especially those unofficial practices not enshrined in policy, because they probably are the highest risk. There's a reason they're unofficial, right? This is not something that takes a heck of a lot of time, but just going through and listing all the different things you do to promote DEI, looking at your trainings, and making sure there are no issues there, in this new environment. So I'm going to open it up for questions, and we'll go from there. You could put them in the chat, or I guess just raise your hand at this point. Anybody?
You did such an excellent job. No one has any questions.
Well, there was a question that we were thinking about that I'll answer myself. And some of you might be thinking of it. If the political winds change again, right? Let's say Democrats come into office in 2026 and 2028. Does this just go back to where it was pre-Trump administration? And, Joyce, I want your thoughts on it as well, but I don't think so, right? I think we're dealing with basically two revolutionary moments. The first one was DEI itself, especially at its outer limits. And then we had the counter revolution, which is, the Trump administration's policies. And I think the dust is going to settle somewhere in between, where DEI remains important, but it doesn't go to those extremes, and it's just a lot more self-conscious going forward. So I think the goal is to try to establish policies and practices that are going to follow that middle road, so then you don't have to be going back and forth based on, the political winds. Joyce, any thoughts?
I definitely agree. I mean, again, when you read the case law that has, been, the sort of inflection point of these changes, these are cases that I think, could have been brought even before, but these good facts made this type of law. And I think what you're going to see is, sort of a normalization come out of all of this, where you're going to continue to see claims like that might have been brought, but now we're going to see a lot more. People are going to be standing up to do it. I don't think it's going away, even if we do have an administration shift.
Anyone else? Any other questions? Okay, well, we greatly thank everyone for participating. Very interesting topic, and look forward. We hope to do another webinar later in the year. Not sure of the topic yet, but I'm in touch with a lot of you. If there's anything you want us to talk about, feel free to reach out and let me know, and we'll think about that. All right, thank you, and thank you to the Rockville Chamber for hosting us.
Thank
And
you.
thank you to John,
Thanks,
Anthony,
Anthony.
and Joyce. Thank you so much.
Take care.
you.
Bye.
Bye.
Bye.